please help me welcome this great guy, this great gentleman. I mean, his profile is also quite tall, so I'm unable to go through, but he's going to take us through customary marriage, whether it protects women or not. Is it the truth or is it a myth? So to help us do this digest, please help me welcome no other than our good speaker, Dr. Justice Srem-Sai, to do this for us.
Good morning, Madam Chairperson, Honorable Deputy Attorney General, my colleague, and the faculty of Computer. I have several colleagues here. The blushing. I'm happy to be here this morning to help us to have a conversation on this very intriguing topic. I'm bereaved, and I lost my brother 2 months ago. And then my brother, very close. After a few days, my family head called me and said, "You have a new wife." And the new wife is my brother's wife, the widow. So he explained to me my responsibilities towards my new wife. And it was the same as my brother's responsibilities towards her. So this topic, our conversation will be around whether customary law marriage protect women. And when we put it this way, we are comparing with another type of marriage, that is the marriage under the ordinance. The first point is, I'm an academic, so I teach. And when academics pick up the topic, they want to find out, they want to break the topic down and explain the various ways. So the first question is, who is the woman? Previously, this would have been a useful question. But now I think it's important that we consider who a woman is. But I think all of us here, we have a common understanding of who a woman is when we talk of marriage. Because in Ghana, we have only one type of marriage. I mean, in terms of gender, it's a man and a woman, and not any other combination. So, the Marriages Act, which was first enacted in 1884. And at the time, the main purpose, Professor Woodman, so the main purpose of the ordinance was to introduce monogamous marriage to Ghanaians and to give Ghanaians an opportunity to choose whether they want to be monogamously married or polygamous marriage. Because before the act, it appears every marriage was customary law, which is potentially polygamous. Then there was a survey in 1960. That was 3 years before. You can have the second slide. 2 years before the next slide. 2 years before you wrote the article, there was a census conducted, and it showed as of 1960 that when it comes to Akan people, only 4.1% of them signed up to the monogamous marriage, and then among Ewe people, only 3.6. That is 80 years after the introduction of the Marriages Act, that is monogamous marriage. Today, I think the trend has reversed completely. Many more people are interested in marriages under the ordinance, that is monogamous marriage, rather than marriage under the customary law alone. And in fact, people who are unable to construct monogamous marriage, probably because of some other impediments, but in which, especially when it comes to women. most people want polygamous marriage. And there's a reason for that. There is an impression, or there's a school of thought that a monogamous marriage, a marriage contracted under the marriage of the agreed of the marriage gives better protection to women than customary law marriage, especially polygamous. But really, is this claim grounded in truth, or is it just a perception? Now let's digest let's look at the differences in these marriages. I think because to understand the incident, the benefits from these marriages, it will be important to know how they are even constructed and what goes into the marriage. So let's take this customary law marriage. It is simply an agreement between, so there are three things that form customary law marriage. The first one is that at least the parties agree, the man and the woman, to reach an agreement that they want to marry. But it doesn't end there. There must be consent from the families, that is the family of the man and the family of the woman. Now the form of this consent is where the issue is. Is it a formal consent, as in there will be a ceremony, you sit down, the party, the parents will come and agree, or could it be implied from conduct from other behaviors of the parties and even the family? Here it appears the cases tell us that it did not be any formal consent from the family. So, for example, if the man and the woman are often seen together and they attend funerals together, you see them in church service, they are there together. When there is some funeral customary right performance, the two of them come, one plays the role as if they were married. Then the law tells us that under customary law, even when there is no ceremony, formal ceremony of bringing drinks, so long as they have lived and conducted themselves together, the families have looked on and allowed them to carry on like that, they are married. The only thing left now is evidence of what? Consummation. Consummation simply means that they have had sex. After the truth of the matter is that no marriage is valid unless there's evidence that the parties have had sex. So these three things are enough to constitute marriage under customary law. What it tells us is that in terms of the cost of marriage, the amount of money put into marriage, customary law actually can be very, very affordable. In this case, you don't need to give drinks to anyone necessarily, but if they look on and want you to carry yourself out as husband and wife, you are married under customary law. Let's contrast or compare this with ordinance marriage. Indeed, ordinance marriage, you have to agree, the two parties must agree that they want to marry. Here the consent is a bit complicated. When the person is below 21 years, the consent must be from the parents. If you look at the marriage form, the registrar of marriage must certify him or herself that when the person is below 21, the parents have given what? Their consent. But when the person is 21 or more, such consent may not be needed. And then of course there must be consideration. What it tells us is that the ordinance marriage is more formalistic. So there must be, if you go through the marriages, you see that even the venue, the person who contracted the marriage, or the officer who supervised the marriage, all those things are regulated. So there cannot be a doubt as to whether someone is married under ordinance or not, but in customary law there could be a doubt. Now in Ghana, I think Madam Chairperson told us, and that is very true, that we have a hybrid, our law is, we have two laws operating, two types of laws operating at the same time. So most people marry twice, at least twice. So, and they marry the same person twice, not they marry the same person twice. So they often will do the customary law marriage before engagement. And I think we need to stop calling it engagement. It is full marriage, and it's complete in itself, doesn't need any further ceremony to have it accepted by law. And then after the first one, then we do another marriage, which is what either we do in church, some actually do it in church, and then still go and sign somewhere. And so, but at least most people will have two of this, two types of marriage going on. Now, let me conclude. Let me conclude. So what I'm going to say would be a matter of, let me try to explain the background so that I'm not taking out of context. Customary law is subject to what I call formal law, statutory law. In other words, and I think Madam Churches will explain the hierarchy of laws, how laws are like human beings. They have periods, they have periods up to the ones that are young, their grandfather's law. So in the line, customary law comes a bit down there, Customary law may have its own negative side, and it does have lots of it. But there are strong positives to customary law. And so, what we know is that when a customary law or practice conflicts with a formal law, customary law will have to bow. In other words, the statutory law will override customary law. Now, when we talk of protection, the issue is how does it protect? We are looking at a couple of things. We are looking at a couple of things. Under customary law, what we know is that it's potentially polygamous. So a lot of people tend to think that as a wife, you are losing out because you are going to have possibly other rivals. And then if you have 10 things and 2 people are sharing, you get 5-5 instead of one person getting 10. So in a sense, the belief is that the mere fact that it's potentially polygamous gives you less protection. I'm not sure if that is a very accurate assessment of what protection is, because you can be alone and still not be protected. And possibly you can be in pairs and still have a better protection. So that may not necessarily be a correct way of assessing what the protection is when it comes to housing, maintenance, and livelihood. Then we also know, under customary law, it is mandatory for a husband to, provide maintenance to the wife. It is a solid ground of what? Divorce under customary law if you are not taking care of your wife. Your wife's complaint could lead to divorce, and she may leave you before you realize, and you cannot have any remedy when that happens. So maintenance is a primary and a very serious matter under customary law. When you look at ordinance, there is no real requirement that a man should, take care of his wife. So then again, when we talk of protection, it appears customary law is having some higher, protection there. Then we talk of when the man dies in terms of widowhood. I just told you about my uncle, the family head, who called me and gave me my responsibilities towards my wife, my new wife, my deceased brother's, wife. And I told you that it's almost the same as what she was enjoying before. So again, it is a serious matter, and in fact, the case law on the matter from pre-colonial time confirmed this, that when a man dies and is survived by a wife, the man's duty transferred to the family, and the family is supposed to house the woman up to the time that she marries another person. And they are supposed to give her livelihood. In fact, not just the woman, but even the children. And indeed,
If the woman is interested and another man in the family is interested, they may just marry and then continue the relationship, because it is a union between the two families, and that union is intended to last forever. So the point we are trying to make here is that when under customary law, when the husband dies, the family of the husband are supposed to what? Perform the same responsibilities that the husband used to perform to the wife. This is not available under ordinance marriage. Ordinance marriage, when you die, there's no law which says that another person should take care of you, should provide for you or anything. So again, here we have a situation where the customary law is still ahead of ordinance marriage when it comes to protection. And then, please, can we go back? Now, this is Woodman in 1963. At the time, he was discussing this same issue between ordinance marriage and customary law marriage in an article which he titled "The Benefits of the Wives, under customary law marriage." And I think the reason why a lot of people believe that ordinance marriage offers a better protection is that at his time, what was happening was that when the ordinance, the Marriages Act was passed, the Cap 127 was passed, there was a provision. That provision is no more there. So whatever he said at the time doesn't apply anymore. There was a provision which gave distribution of estates which does the distribution of the deceased person's estate in a way that you are more secured under ordinance marriage than under customary law marriage. So the myth which we are dealing with today, where a lot of people want to contract ordinance marriage at all costs, was based on a provision in the Marriages Act, which provision has been repealed and is no longer there. However, the customary law marriage benefits are still there and have not been repealed. Now, the effect of this is that when you do the analysis, it appears that the customary law marriage gives a better protection, and that there is no protection that you will get under ordinance marriage which is not available to customary law marriage. That is because the Constitution itself does not distinguish between ordinance marriage and customary law marriage when it comes to spousal property rights. It simply uses the word spouse and spouses, spouse and spouses. So there is no evidence within the Constitution that it gives a better standing to someone who is married under ordinance over someone who is married under customary law. Whatever you would get as of right under the Constitution, you would get it whether you are married under customary law or ordinance. Ordinance law. The second law, which is the Wales Act, which also governs the sharing of property, also uses the word spouse, because there's a provision in the Wales Act which says that when a man or a spouse dies and makes no or not enough provision for the wife, the courts can take part of the estate and give it to the wife or the husband, by force. So some of you here, you have secret plans not to include your wives in your will. It won't have any effect, because at the end of the day, the court itself will take some and give it to them. So better give them enough so that the court doesn't even take more than you actually intended to give. On this note, I would like to thank you all of you for being with us. Have a nice day.